Hey guys, today we're going to talk about a common clause in wills. It's called the trustee discretion clause. The trustee discretion clause usually go along the lines like, my trustee shall have full power to postpone the sale, calling in, and conversion of the whole or any part of my estate for so long as my trustee shall in his or her discretion think fit without being liable for loss. What's the purpose of the trustee discretion clause? Well, in the case of immovable property, for example, a HDB flat, a condominium or house, if the testator, the person who made the will, bought the house at $1 million, at the date of his death, the house is only worth $500,000. So, this clause allows the trustee to postpone the sale. That means he doesn't have to sell the house immediately after probate is obtained, because sometimes there may be several beneficiaries under the will, and the beneficiaries may be very kanchiong to get the money. They want to get the money, so they might take legal action against the trustee for not selling and disposing of the assets and distributing the money to them. So what this clause does is that it protects the trustee. The trustee can decide to sell the house later when it has gotten back to the original value, perhaps 1 million or maybe even 900,000. The same principle applies to things like shares. So for example, if the testator paid $3 for Singtel shares, after he died, the share drops to $2. So this clause allows a trustee not to sell the shares, but to hold onto them on trust, until it has returned to the former value, so that there's no loss to the beneficiaries. The Court of Appeal in Fuji Sing and Fuji Tuang decided that a court can intervene to order the sale of a property, even when a will states that the trustee has absolute discretion to postpone it. But it should be noted that the court will only intervene if the trustee's behavior is not reasonable, and the court will have regard to the testator's intention. That means the person making the will, his intentions in creating the trust for the sale of the property. And the court will also take into account prevailing circumstances, whether it's reasonable for the trustee to behave like that, to withhold the sale of the property. For example, if the property was bought at 1 million, it is worth 1.1 million now, and the trustee still does not want to sell it, the court may find that the trustee's behavior is not reasonable, and it may order the trustee to sell the property. The Court of Appeal emphasized the importance of a fact-sensitive approach in determining whether to intervene in such a situation when the trustee does not want to sell the house and relies on the trustee discretion clause. Additionally, although a trustee is not obliged to follow the beneficiary's wishes, he cannot disregard the beneficiary's objective needs and interests in deciding when to sell the property. So even though the trustee is not obliged to listen to the wishes of the beneficiaries, they keep hounding him to sell the property, he cannot disregard their needs and interests. So for example, if one of them is broke, needs money desperately for medical bills or what, the trustee has to consider such factors when determining whether or not to exercise his discretion to postpone the sale of the property. So thanks for watching this video on trustee discretion clauses.